Amy Schmitz is a professor at the Ohio State Moritz College of Law and the program teaching also in the program on dispute resolution as a John Deaver Drinker Baker and Hostetler Endowed Chair in Law. I look at my notes for that because it's a very long title. So you're also the co-director of the Transnational Data Analytics Institute, responsible data science research community of practice. You have been the co-chair of the ABA Technology Committee of the Dispute Resolution section of the ODR Task Force. You've been hosting a series of podcasts and blogs on the topics of arbitration, which we will be also discussing today. And you've been a very recent award recipient of the Association of American Law Schools section of Technology Law and Legal Education Award. And we would like to congratulate you on that. So today we would like to discuss a little bit about the future of arbitration. And my first question for you is for the people who are not really familiar with arbitration. What is arbitration? How do you define it? Very briefly, at least.
Yeah, so arbitration is different from other dispute resolution mechanisms. We talk a lot about negotiation and mediation, and it's very different because it's completely voluntary. It's not binding and final. Arbitration is very different in that you have a final and binding determination that is enforceable under the law. Internationally, arbitration agreements and awards are enforceable under the New York Convention, and the New York Convention has been adopted by almost every nation in the world. It is incredibly popular, it's very useful in terms of especially business-to-business arbitration. But you have a final and binding award, and that is the difference between arbitration and mediation, for example.
Okay, thank you very much. So you say that many countries in the world have adopted the New York Convention. It has been probably out there for quite a while. How has it been? What has been the process of adopting it? What was the inspiration behind it?
Yeah, so the inspiration actually came from the Federal Arbitration Act, which was an American law, which has really quite an interesting history. Back during the Revolutionary War, when the British were fighting, of course, with those in the American who were trying to break away as a colony and gain their independence, the courts were closed, but merchants continued to trade, and they used arbitration as their dispute resolution mechanism. So it was very much among the traders and the merchants of the day, and lex mercatoria, the law of the merchant, really prevailed at that time. And so arbitration really grew in use as a business-to-business commercial means for resolving disputes. And it was especially important because they wanted to use norms of business, not simply legal norms, but they wanted to include equity and rules of the trade. We even saw arbitration mechanisms within particular types of traders. So the diamond dealers had their own way of arbitrating. So this became a very big aspect of the growth of industrialization. And so then what happened is during that time, after the Revolutionary War, arbitration continued, but then the courts started to get jealous because all the good cases were going to arbitration and not to the courts. So they started developing doctrines of ouster and revocability. Ouster meaning you can't oust the courts of jurisdiction, and revocability meaning that you can revoke your agreement to arbitrate at any time. Well, during that time, the New York Chamber of Commerce, the business people, got together and said, well, this is no good. We want enforcement of arbitration. So in 1925, the New York Bar pretty much wrote the Federal Arbitration Act, handed it to Congress in the United States. Congress, of course, thinking they're the merchants, they have all the money. Yes, of course, so they signed off on it. It became the Federal Arbitration Act, and that's actually the precursor to the New York Convention. Many of the same provisions that are in the Federal Arbitration Act are in the New York Convention for enforcement of international arbitration.
And what was the reaction of courts after the adoption of the Federal Arbitration Act?
Yeah, so of course they had to enforce arbitration agreements and awards. But in those days, they had many exceptions. So when things would go to the U.S. Supreme Court, and plus it was thought that, well, this is only meant for business to business. This is not meant for consumer or employment or other areas. For many, many decades, that is the way that the Federal Arbitration Act was enforced. It was really only in those commercial areas that we saw the use of arbitration. Now, labor arbitration in the United States was under a separate law, but for commercial business to business, that was the Federal Arbitration Act. And the Federal Arbitration Act really was not touched until they added a provision in the 1980s that had to do with immediate appeals from final orders. Very small, not a big deal. And then pretty much nothing really happened with respect to law until last year was the first real amendment that we've seen to the Federal Arbitration Act for many, many years.
And what was the purpose of this amendment? Was it a big change, a small change?
A small change, but it's sort of important. First of all, we saw in the late 90s a real growth in the expansion of the enforcement under the US Supreme Court. So in the United States, they started enforcing arbitration in employment and consumer claims. Now, that had been sort of unheard of. When I first started teaching arbitration, my book was commercial arbitration. I taught commercial arbitration. Suddenly, I've got consumer, I've got employment, which is really different and distinct from the rest of the world, in fact, but very much a part of American jurisprudence. Well, fast forward to last year, and there was a lot of concern about arbitration where you have sexual harassment claims because it's keeping it private, it's not allowing people to voice, to get it out there in the open, to obtain class actions and remedies that they need for public policy reasons. So we had what we call FSASHA, which was ending forced arbitration for sexual harassment claims, which was a big change for us under American law.
Okay, and so there is a really, we see that there's a need to update this old legislation and maybe also to update the convention, the New York Convention on Recognition of Enforcement of Arbitral Awards. But my question is with regards to the future. We see that there's a lot of development with new technologies. And my question is, how has this Federal Arbitration Act and the New York Convention been dealing with technologies? What are the key challenges? Are there any challenges, and what are they?
Yeah, it's really quite fascinating to think about because, of course, in 1925, I mean, that would be unheard of. The idea of virtual arbitration, the idea of e-contracts, the use of technology. They didn't even know, obviously, what the internet was. You know, it wasn't even around. And so we've seen courts struggle with use of virtual arbitration under the stark provisions of the Federal Arbitration Act. I mean, part of the success of the Federal Arbitration Act is the fact that it's very short. My students love it, right? Because it's super short, it's easy to read, and of course that made it very adaptable and useful for the New York Convention to be the basis. Because it is so simple, it leaves many questions open to interpretation, which means we end up with a split in authority, and under common law, judges are allowed to essentially make law. But what happens when courts disagree? And we've already seen this happen with virtual arbitration under Section 7 of the Federal Arbitration Act. It's quite interesting because the Federal Arbitration Act allows for subpoenas to have witnesses come and appear before them, quote unquote, meaning before the arbitrators. The question for the court is, does that mean physical presence? What if they're virtually before the arbitrators? Is that sufficient? Do you have the power under Section 7 of the Federal Arbitration Act to order somebody to a virtual arbitration? And that there's a split in authority on that question. So that's created some problems if you, for example, want to be involved in what I call OARB, online arbitration, because now what happens if you need to subpoena third-party witnesses? Now that becomes a problem for third-party witnesses, not as much for parties to the actual arbitration agreement, because those parties will have agreed to particular arbitration rules. The arbitration rules of the various bodies like the ICC, the International Chamber of Commerce, the AAA, American Arbitration Association, the International Center for Arbitration, they all pretty much allow for, among parties, to order attendance, order providing documents. But if you need to get the court's assistance in order to subpoena a third party, you could run into problems for virtual arbitration due to this outdated language in the Federal Arbitration Act.
So that's the first key challenge, is understanding the notion of before the court.
Yeah.
Are there only other issues that may be a little bit pressing?
Yeah, so one question for the New York Convention. Now, under US law, we've been able to sort of answer it with a majority opinion that an e-award, an electronic award, is sufficient. It's considered a writing for enforcement under the Federal Arbitration Act. We have the e-sign act under US law. But this has become a problem on an international level. The question is it sufficient for enforcement if it's a virtual, if it is an electronic award and not a paper written award with actual signatures, right? And so this has become another question that we have under international law with respect to enforcement.
And how is this, in which direction is this going? Is it going to be recognized in some way, or are there going to be amendments for the convention on the New York Convention?
Yeah, so now these are separate questions in my mind in terms of the Federal Arbitration Act and the New York Convention, right? Because you have different issues there, certainly with the lawmaking aspect. Now, under the Federal Arbitration Act, we're coming up upon, which is perfect for Radboud's 100th anniversary. In fact, the Federal Arbitration Act is coming up on its 100th anniversary. And there's quite a few scholars and commentators who are now saying it's time for an update. So we could see an update in the coming years. There's a large book project that I'm part of, and I'll write a chapter in it, and others will write as part of this book, and it's all going to be about possible changes that might be necessary under the Federal Arbitration Act after 100 years. You know, it's outdated in different ways. What are some of the changes that might be necessary? We might need to rethink this consumer and employment arbitration use, because in fact, under US jurisprudence, there are quite a few individuals who say, well, wait a minute, when the Federal Arbitration Act was passed, when it became law, it was meant for business to business, not consumer and employment disputes. So there's quite a bit of controversy around this. Well, the courts don't seem to be willing to change that because they've expanded the scope. So it would now be up to the legislature to change that. On the international level, I have more skepticism about a change in the convention. We both know that actually changing a treaty is quite laborious, right? And there are very different feelings about the use of technology in arbitration. The Singapore Convention that recently has become quite prominent in the news, and we of course saw the UK sign on
Maybe
most
explain
recently.
what the Singapore Convention is about.
Oh
for
yes,
our
so the
audience.
Singapore Convention is the enforcement of international mediation. So it's looking at mediation as opposed to arbitration, because there is a growing use of mediation. It's quite useful in many different types of disputes, bringing people together to form their own agreements. The questions now will be about virtual mediation and what happens with online dispute resolution, because there are not clear provisions in the Singapore Convention with respect to the use of technology.
Although it was a very recently adopted instrument. So yes, I can see the changes there. So we already mentioned the issue of appearing before the court as being an issue. There is the issue of signature. I was wondering whether there might be other issues at stake, for instance, for the location of the seat of the arbitration or for due process. Maybe let's start with the location of the seat.
Yeah, you know, I think what's really going to be sort of we already have questions, and this is actually under the New York Convention and Mexican law, but there's blockchain arbitration. In blockchain arbitration, there is no location, right? Because the idea of blockchain is that it's a distributed ledger using computers throughout the world, right? And so it's distributed by virtue. And so with tokenized, Kleros is the company in particular, and they use tokenized, meaning virtual tokens, essentially cryptocurrency, where the various jurors are voting with cryptocurrency from all over the world. So where's the location, right? And we did see a Mexican court enforce a Kleros arbitration award, blockchain arbitration, but that was a very particular case because the individuals had an arbitration agreement that agreed to use the Kleros arbitration model. So their location was actually the location of their agreement, and so they did have this contract that allowed for enforcement of the arbitration award, because even though Kleros procedure was used, the arbitrator had to approve that arbitration award. So it was still adopted by a particular arbitrator located in Mexico. So that was allowance for it to be enforceable. Now, what happens if you don't have that additional agreement? Do we have a way to enforce these sort of blockchain arbitration awards? Let me go a step further. What happens with metaverse, right? What if we have arbitration in metaverse and it's completely virtual, and you're using avatars? Who are the individuals? Who's the arbitrator? What if they're all anonymous? Now what?
Do you have any suggestions or good practices?
Yeah.
Maybe from the Kleros agreement we can see that maybe putting something in the contract is already a good start, but maybe there are things to...
No, I mean, I think that's excellent. I think, you know, we were talking before the podcast about the importance of contract law. I also teach contract law, and I'll never let go of my contract teaching, because I do think that's the basis, right? If you've agreed to it, that makes for enforcement and helps tremendously. If you agree to that process and it is a sufficiently fair process, that's the question. Is it an independent third-party decision maker? That's very important to deciding whether or not it's quote-unquote arbitration that's enforceable under the New York Convention or the Federal Arbitration Act.
And maybe for third parties, is there any way to make sure that there's some fairness for the third parties?
I think we do run into, I think as long as it's an independent third party and it's your agreement, so if you and I have an arbitration agreement, we end up with an arbitration award. Now, that's a totally additional question as to its estoppel effect, its collateral estoppel effect, or its res judicata effect with respect to third parties. And now that is another legal question that we need to ask. Did that third party have a full and fair opportunity to get their concerns raised in our arbitration? Now, I would argue no. For example, if we use tokenized voting on the blockchain, because how would they be able to, their questions or concerns would probably not be sufficiently represented by our arbitration. But we would have to look at the particulars of that arbitration, what happened within that arbitration, what interests were represented, right? But that's a separate issue when we get into third-party estoppel effects or res judicata.
This is indeed very interesting, and it may be linked to the fourth challenges, which is about due process and fairness in the procedure overall. What do you see any issues in the fairness of the online proceedings with, I don't know, video conferencing being used on arbitration?
Yeah, I mean, I do think OARB is the future, right? Even when we think about sustainability and the environment and climate change. It's quite important, and there's quite a few mediators and arbitrators who have signed the Green Pledge. And the reason is because...
Can you maybe explain what the Green Pledge is?
Yes, I absolutely will. Yeah, first of all, I do like green, and it's my favorite color. But putting that aside, it is actually quite important, because think about all the travel of the original days. I think back to when I was practicing law. And at a big law firm, we would fly all over the place, constantly in airplanes, all that carbon emissions. Think about what we did to the environment, right? And lawyers are notorious for this, and business people as well, right? So continually flying all over, all the witnesses, everyone having to converge in one place, go to New York City, go to London, go to Paris, the main hubs, Hong Kong, places where they have these large arbitrations, and all these individuals with all that travel, all that paper, right? It's really not good for the environment. So there are mediators and arbitrators who have pledged to use more virtual hearings, because it is quite helpful to not require all that travel. Better for the environment, cut down on use of paper, use more electronic agreements, and even with the exhibits, it's quite handy actually in an arbitration to have all of your exhibits online ready to go. That said, I do think there are concerns. I always think about fairness. Fairness has to win. There's this battle of fairness and efficiency in conflict resolution and in due process, right? But we have to think about fairness. And so often what we're seeing growth of are use of due process protocols. Now, protocols are soft law, but we see a lot of soft law in arbitration. And so what we're seeing are different ethical pledges having to do with due process and protocols in place for when you're having a virtual arbitration. And there are actually mechanisms. I created a chart you can find for free on SSRN, and it's the OARB protocols, so online arbitration protocols, that different bodies started creating during the pandemic because there was so much virtual OARB being done during the pandemic. I think about it really sort of history repeating itself in the sense that during the Revolutionary War, right, all the courts are closed, but the British are still arbitrating with individuals in the colonies of the Americas because they're still doing business. Similarly, during the pandemic, when courts were not getting up to speed, they were not fast in getting online, arbitrators were very fast in getting online. And so arbitrations and online arbitrations continued. And so we now see more and more mediators and arbitrators very comfortable with use of virtual arbitration. And so I do think OARB, it's the future. We're going to see also hybrid, where, for example, the parties might agree that they want to be in the same location, but all the witnesses can be heard via video testimony. That said, We do have protocols in place to ensure fairness.
And what is the content of those protocols?
Yeah, so there's a lot of different protocols out there, and so I invite any listeners to really look at that full chart, because there's really tremendous work that's been done on an international level by different authorities throughout the world who have written different protocols. So take a look. There's a lot of intricacies around it. But one of the big things, I think, is as an arbitrator, you always want to do a test run using the exact same technology, the same computer, the same cell phone, the same everything that you're going to use for the actual arbitration, and ensure that all parties have equal access to the technology, because there is still a digital divide. The digital divide may not just be access to the internet itself, but it could actually be your type of technology. For example, if I have double screens, beautiful lighting, perfect microphone, I'm going to be able to present my case better than you if all you have is a mobile phone, right? So if you're an arbitrator, you have to think about that and maybe say, you know what, we have to be in person for due process to make sure that everyone has equal voice. Equal voice is very important to justice and access to justice.
So is that decisions that the arbitrator could make, is to switch back from the online video conferencing or online arbitration back to regular offline arbitration? Is that a good practice that you may suggest in some circumstances?
Yes, I really do. And also for that arbitrator, even if we don't want to sort of assume the best and goodwill on the part of the arbitrator, it's also important for enforcement. If, in fact, you did go through and sort of trudged ahead and forced an arbitration where one individual did not have adequate access, that arbitration award may not be enforceable. You could absolutely challenge that award under the New York Convention and under the Federal Arbitration Act, under the provisions with respect to overturning arbitration awards. So having a full and fair opportunity to be heard is quite important for the enforcement of the award.
Okay, thank you very much. And so are there any fifth maybe challenge that you would like to stress or to highlight?
Well, I also think credibility. There are a couple of other sort of good practices as an arbitrator. Number one, you will want to ask each individual to sort of take their camera and pan the room, that there's nobody else in the room, that you're not being coached, that there's nothing inappropriate that's happening. You're going to want to use cybersecurity, have very locked down, password protected hearings, right? You don't want any Zoom bombers, but you really want to be careful in your use of that technology. Cybersecurity is tremendously important in online arbitration. You also need to have a secure platform for exchanging documents. Email is not secure. We all know that. So you really need to think about cybersecurity. You need to think about fairness. You need to think about transparency and making sure that everybody is on the same page with respect to the process and procedure when it comes to the use of that technology.
So we've seen mostly issues with regards to how to apply the FFA and the FAA, sorry, and the New York Convention. Are there also changes with regards to the competency of the lawyers with regard to new technologies?
Yes, thank you for asking. I'm sort of passionate about this. In fact, under the rules of professional responsibility in the United States, there is a rule that requires technological competence. Is the same in Europe? Do they have the same sort of technological competence yet?
There may be, depending a bit on the member states. There are some standards. Yes.
And I think we're going to see a growth of that, right? And then it will be a matter of, if we know that these technologies are available, and we have a duty as lawyers to also have efficient, to not create expensive processes for our clients, we may be required to suggest the use of online processes in order to keep the costs down for our clients. I think that's the right thing to do from an ethical standpoint, and I do think new duties are abound to learn about technology for up-and-coming lawyers.
So there are duties for efficiency and cost effectiveness of dispute resolution in the terms of the advocacy and the role of the lawyer into helping the clients. But do you think that maybe insurances can also do a little bit of policing?
Yeah, I think we're going to see more of that, especially under the different policies that you sign up for as a law firm, right? You might have the insurance company come in and say, wait a minute, we don't want to end up with malpractice claims, so you need to learn about this. And not just the efficiency. I want to put on my other hat for the responsible data science, for the Translational Data Analytics Institute. The reason I started working with them is specifically to learn from the computer sciences. It's definitely a multidisciplinary approach. And learning about, wait a minute, as lawyers, we also need to understand responsible data science. Learn, wait a minute, ChatGPT and all these new, shiny new toys. Well, what are the concerns there? Are there bias issues? Are there additional pieces that we need to understand? And from an insurance and liability standpoint, it's also important to understand what risks might there be in using that technology.
So you're mentioning ChatGPT. It may be just a hype at the moment. It might become something a bit bigger in the future, or it might just completely disappear. I'm not doing any futurology.
Right.
Or it might be becoming a paying tool, and then no one else will be using them. Maybe a few law firms who will be able to afford it, or some companies who will be able to afford it. But do you see any opportunities for the arbitrators or for the lawyers in using these technology, generative AI, for instance?
Yeah, I do. I do. So, and again, everything old is new again, right? So when you go back, and I remember as a young lawyer, we would use forms. This was a thing back in the 1990s where you would use a form. You know, you have a big deal that you're doing, a very important contract. Well, you might look at past examples, what we called forms. And within large law firms, I was at a huge law firm, first Minneapolis, then another law firm in Seattle, where you had this database of these forms. And you would use the forms as a starting point. Now, it'd be malpractice. You would never just use the form wholesale, right? But as a young lawyer, you would use it as an example, a starting place, right? I think we're going to see the same thing with ChatGPT, and we're already seeing it. For example, it can help you generate ideas and options. There's a company called Next Level Mediation, and they're already using ChatGPT to help a mediator generate options and ideas. Now, there still has to be a human in the loop. It's still the mediator who's making a decision, like this is garbage, but this might be useful. So I think we're going to be seeing more use of iterative AI, different forms, more advanced. It's going to keep getting smarter. And we're already seeing, I've spoken with different sort of groups that are using the data within, for example, arbitration, using that data, learning from that data in order to help arbitrators generate questions, generate options, think about ideas that they may not have thought of, right? And so it can sometimes be helpful for generating ideas and options and a starting point.
So it's thinking out of the box a little bit.
Yeah, and remembering to sort of, oh, I didn't ask that question. I probably should. Now, is it perfect? No. I mean, we've all sort of put in different questions and you get sort of crazy answers, right? ChatGPT is not perfect. But I do think iterative AI will just keep getting smarter.
It will probably keep smarter, but we need to just check a little bit as to not just apply directly. And
definitely. That would be
no template, no boilerplate, no template, just thinking. Really support the decision-making of the lawyer in supporting the clients.
When we talk about AI, we talk about a human in the loop, a human on the loop, and a human out of the loop.
Can you maybe explain the difference?
I would love to, because I think it's really important. And I think it's helpful for my thinking, at least. A human in the loop means that no decisions are made, nothing would happen, the arbitrator would not do anything without being in that decision-making process. So for example, if ChatGPT put out a bunch of ideas, I could easily just ignore all of them and still do something entirely different and look at my own research, my own judgment, my own analysis, right? There's a human in the loop. There's nothing happening without my decision-making process. A human on the loop is what we often see in, for example, customer service. We've all been there where the first line of defense, you put it in there, you ask a question and you know it's a robo answer. And it's saying, you know, whatever, here are a few things you can look at, here's an article, but you still have a human on the loop, meaning when that isn't working, you can get a human before there's an end process, right? So there's a human on the loop checking it, kind of over it. But still, things can happen without the human. And we see that quite often in those areas. Now, there's also the human out of the loop, that's where there's no human available. I would argue that that's true in many customer service situations. I've been there, I don't know about you, but anyway.
I've been also there.
Yeah. And I think, for example, Amazon's Alexa, which are those small little devices that many individuals have and use to say, what's the weather, or play this music, there's no human on the loop. It's just using the AI in order, and if it doesn't answer, then you say, Alexa off, and you just turn it off because it's not going to work.
But maybe for judicial decision making or for arbitration, it may be interesting to still have a human on the loop.
Yes, you have to. In my view, actually, we're still at a stage where we need a human in the loop, not even just on the loop, because humans are not very good at being on the loop. And I'll tell you why. We're lazy. Humans are lazy. There's actually been some research to suggest that humans are not very good at being on the loop, because what happens is we'll let the self-driving car crash because we aren't being vigilant. We're thinking, the data will take care of it. We'll just let it go. I want to go and have a cup of coffee, right? And so really to make sure that at this stage of the game, when it comes to judicial processes, arbitral processes, especially arbitration, because again, it's final and binding. So it's very important that we have a human in the loop, right? Still having that independent judgment being used before anything goes out to any final and binding decision.
To compel the human to think about it rather than to just rely on the technology and be lazy, as you say.
Yes, yes.
So those are, I think, the main challenges that we can identify, and keeping the human on the in the loop and not on the loop is also probably a very important challenge. Where do you think that the reforms will be going? Where do you think that the FAA will be going, or the New York Convention? Well, it's also now 70-year-old. So do you think there will be reform, or the system will completely crash and then we will have to start and boot it all over again? Right.
Well, I think I'm not entirely sure what will happen specifically on those aspects, but I do think what is going to be important is the overlay of additional law that's going to be coming in with respect to AI, privacy. Obviously, we've already seen the GDPR. We, of course, know the AI Act has been proposed in Europe. We know the AI Bill of Rights came out of the Biden administration in the United States. Canada has a directive on use of automated processes, and I think that's going to be an important overlay. And the reason I say that is because I'm seeing within administrative processes, in these small little areas, we're starting to see more use of AI and data analytics in order to spit out quick, efficient decisions. What I worry about is the battle between fairness and efficiency. There might be areas where efficiency, on the government standpoint, administrative processes, for example, where they say, wouldn't that be nice to push that off to the robo-judges, right? And that might work in some very small areas, right? But we need to be careful about that. And so I am passionate about responsible use. I definitely am not one of these people where we just rule it out and go back to, stone tablets and chip away. I think we embrace technology. It's not going away. It's just going to keep increasing in use. So it's up to us to learn how to use it as a problem-solving tool. So I think that will have an important legal overlay over the Federal Arbitration Act and the New York Convention, is the use of these technologies. Because again, it's only going to increase in popularity, in use, and reliance. We even see the younger generation saying, you know what, I trust data analytics, I trust AI more than I trust humans. So we are going to see a growth in these processes, and what we have to do is figure out the best way to regulate for responsible use of those very powerful tools. I heard a speaker, and think about everything, that 5 years ago, would we even imagine that there was such a thing as ChatGPT? No. I remember talking about OARB 15 years ago, and people thought I was crazy, this will never happen. This was just me being, musing as some silly professor. So I really think that the future, we're definitely going to see more and more technology. The question is, how do we best use it as a tool to solve problems and not create problems?
So that's indeed an important takeaway. Is what do we do with the technology?
Yeah.
We need to think to be solution driven, and not only thinking about what we often do as lawyers. Probably is to look more at the problems than the solutions. But we need to be constructive. We need to embrace it. But as you said, technology is not always a solution for all the issues.
No.
Sometimes it's maybe good to come back in person and have a one-on-one discussion or an arbitration with the parties in presence, and having a hybrid form. So technology is not the solution in all the situations. So
no, and in fact, I really think it's important. Our human aspects, there's something very special The other thing I must say about data, it's history. It's not good at creative problem solving. That's forward thinking and able to evolve. But as humans, we really are better able to do that. Moreover, there are very important psychological aspects and social aspects. I do believe strongly we need to break down silos and work with the sociologists, the psychologists, because there are aspects to dispute resolution that are very focused on our psychology. And for some individuals, having that cup of tea, sitting down and talking is actually how they get resolution. And even from a due process standpoint, you have to think of process satisfaction. Process satisfaction really does depend. How do I feel about that process? Do I feel that I was heard? Now, for some individuals, they'd be very happy using technology and feel very heard, feel better about it, it's less stressful. Other individuals maybe do want to sit down and talk about it, have a cup of tea, and then we feel like closure, that ability to move on with our lives. And that's really important. That's something money can't buy.